Welcome to Once Upon a Case. Because the law isn't just for lawyers, it's for everyone. Let's break down Foster v. Svenson from 2013, one of those cases that makes you rethink your own windows. Picture this. You're chilling in your own apartment, thinking you're safe from the outside world. But then you find out someone's been taking photos of you through your window, and they're showing those pictures off in an art gallery. Yeah, that happened in New York City. So here's what went down. Andrea Foster and her family lived in a fancy glass apartment building. Michael Svenson, a photographer, lived across the street, and he had a thing for candid shots. He used a telephoto lens to snap photos of his neighbors inside their own homes. Not outside, not in public, literally inside, living rooms, bedrooms, other interiors. He then included those photos in his art exhibition called The Neighbors. Now imagine how you'd feel. Foster and her family sued Svenson, arguing that their privacy had been totally invaded. They claimed Svenson violated New York's privacy laws by using their likenesses for commercial gain without permission. I mean, who wouldn't be freaked out? But here's where it gets wild. The court had to decide, is this invasion of privacy, or is it protected art? In New York, there are strict privacy laws, but there's an exception for works that are newsworthy or of public interest. Here's the twist. Courts have sometimes said that art falls under that exception too, so the judge ruled in Svenson's favor. The court said his photos were artistic expression, not commercial use, and therefore protected by the First Amendment, free speech. Even though the Fosters felt violated, the law basically said, sorry, but you live in a glass building in New York, and what you do, even inside, can sometimes be considered public. Now this case didn't just affect the people involved. It fired up debates about privacy, art, and what's fair game in the digital age. Suddenly, everyone started asking, should artists have the freedom to use anyone as a subject, even in private spaces? Or should there be limits? So, here's the takeaway. If you live in a glass box, you might be in someone's next art piece. And if you're an artist, the law might have your back, at least in New York. Foster v. Svenson is a reminder that the lines between public and private are blurrier than ever. Think about that next time you walk by your window. Thanks for watching. Stay curious and keep your curtains closed if you want some real privacy. If you want more cases explained just like this, hit that subscribe button and I'll see you on the next one.